Olá a todos, sejam bem-vindos. Hello everyone, welcome to our Unitary Patent and the Unified Patent Court webinar. First of all, I will be speaking in English as well as our speaker, Koen Vanhalst. But I'd like to highlight that we have interpretation, simultaneous translation. You just have to press the button interpretation in your Zoom webinar application. So I'd like to thank you very much for being here today. My name is Felipe Oquendo. I'm a lawyer and a senior associate to Dublasi Parenti. And I specialize in patent litigation. Before starting, I have just a few remarks. Thank you for your audience today. I know that today is a very special day. It's World IP Day. Very good day, momentous day for learning and sharing. And I also know that there are a lot of webinars and events going on. So thank you for choosing us and allocating our time today to hear about the Unitary Patent and the Unified Patent Court. I'm very honored that he accepted to talk to and speak in this webinar. So without further ado, I will present Koen. Koen Vanhalst is a partner of Belgium law firm the Clercq Partners, Intellectual Property. He holds a PhD in biotechnology from the University of Ghent in Belgium. Koen is also an active member of the AIPPI and is vice president of the Belgian Institute of Patent Attorneys. So Koen, the floor is yours. Thank you once again.
Thank you very much, Felipe, for the introduction and for inviting me. I'm very happy to be here. It's always a pleasure to explain a new system. So, bom dia a todos. I'm sorry my Portuguese doesn't reach much further than that. Good morning to everyone. And let's just get started. So today we will talk about Unitary Patent and Unified Patent Court, which is by far the largest change, I think, in the last 50 years in the European patent system. So that's why we thought it was helpful to give you some insights. So on the menu today, we have three aspects. One is the Unitary Patent. The second one is the Unified Patent Court, which are two different systems in a way. So first we start out with a little bit of history. As you probably all know, the European Union is kind of a strange region. It's not a single country. It's not like the United States of America, where you have like this federal structure. We have a bunch of individual countries, basically, which means that we also have national patents. So we have Belgian patents, we have German, French, UK patents, and so on. Each country has its own patent system, its own patent law. And on top of that, we have the so-called European patent, which is covering all the member states of the European Union and beyond. And I will go into that in a bit more detail. So these two systems exist today and will continue to exist also in the future, regardless of this new system. So national patents, as I already said, means that you have separate filing of the application, separate examination, if there is any examination, and separate grant or allowance of the patent in each country. Also implies that you have to pay annuity fees every year to keep them in force, and you have to have a local agent, a Belgian agent, a German agent, a French agent, and so on. So you can already more or less realize that this is not going to be the cheapest option. It also implies different languages. I'm not sure how many languages we have in Europe, but it's a lot. And every country basically requires that the patents are filed in an official language of that country. Also, the prosecution has to be done in a specific language of that national system. So it's quite a complex situation if you're talking about national patents. This was optimized in the late 70s with the installment of the European Patent Convention, which grew quite a lot in the end. We have now 39 contracting states. That includes all the member states of the European Union, 27 member states of the European Union, plus 12 non-EU countries. Examples, of course, the UK, which exited the European Union a couple of years ago, but also Turkey, Norway, Iceland, and so on. So that's what we call EU plus, if you like, combining 39 states in total. And in all these 39 countries, you can have with a centralized procedure a European patent. It means that the European Patent Office, which is issuing these patents, centralizes everything from filing up to grant and a little bit beyond. So third parties can oppose a granted patent, but the patent owner can also limit the claims of the patent before the EPO, or can even request a revocation of his own patent in case there is, for instance, a breach of contract with a collaborator. All this is centralized. There are 3 official EPO languages, German, French, and English. There is a single annuity fee to be paid pre-grant, so prior to the allowance of the patent. And it can be done through a single agent, like, for instance, myself as a European patent attorney. For companies or individuals that are located outside of the European Union, you actually are required to hire an agent within the European Union that has qualifications before the EPO. So you need to be represented. But then the problem starts again, because we don't have something that is really called a European patent. You get a European patent granted, but then in fact it kind of falls apart in a bundle of national patents again. So remember the first slide, we have these national patents that are directly filed with the patent offices. Well, the European system is kind of similar. The only thing it does is it concentrates the whole start of the procedure up to grant, but then you again have to choose in which countries you want to have validation. So if you visualize this, we have this central procedure before the European Patent Office up to grant, and then what we have the so-called validation phase, where you again have to choose in which countries you want to pursue the patent. And in many countries, that also involves, again, providing a translation of at least the claims, sometimes even of the whole patent as such, which, of course, is, again, expensive. But it has also another consequence, of course, and that means that you're not talking about a European patent, you're talking about the German chapter of European Patent X and the French chapter of European Patent X, which means that if there is a court proceedings, an invalidation or infringement action, these have to be done before the national courts. So that is the situation up to today. So there's 2 problems involved there. We have high costs. I think I don't have to explain to anybody of you that have ever used the European patent system that it is comparative to, for instance, the system in the USA, extremely expensive for a more or less similar market size. And it's quite complex because you have to go through all these formal requirements in order to get, for instance, protection throughout the whole European Union. So, for instance, if you would like to have the patents active in all 27 member states of the European Union, that would, up to today, require 11 full translations of the patent, 9 translations of the claims, and you would need to use 21 local agents. So you can already assume how much or how costly that can, of course, be. Other than that, in order to maintain that protection for the lifetime of the patent, which is 20 years, you get a graph like this. So you see that the annuity fees obviously go up in the longer the life of the patent is. that has a certain purpose, of course. The idea behind it is that every patentee is requested to make some kind of balancing exercise every year to see whether the costs of the annuities are still reasonable in view of the value of the patents. If not, he's supposed to give the patents to the public and everybody can basically use the invention. That's the idea behind it. That's why we have these incremental costs. But if you calculate that, for instance, for the 27 European Union member states for 20 years, you end up with paying fees into an amount of 180,000 euros, which is crazy. Yeah, of course, not that many companies or patentees do that. That's more for companies that really have needs this European-wide coverage, like for instance, pharmaceutical companies, because for the rest, it's really too expensive. This is just another example of, if you would, I mean, I'll tell a little bit more why we use this number 17 in a couple of next slides. But these are actually the 17 countries that will participate from the start in this new system. So as a comparison, you would, if you only want to have protection in those 17 countries, today still need 7 claims translations, 5 whole patent translations, and still 12 different local agents. So quite a cumbersome procedure. Problem number 2 is not only the cost for getting the patent and maintaining the patent, but also for having this EU-wide litigation. As I already mentioned, you'll have to have parallel proceedings in several member states in order to, for instance, prove or claim infringement of your patent throughout different countries like France, the Netherlands, Germany, and so on. That, of course, means that you need multiple legal teams because, for instance, a Belgian attorney, a Belgian lawyer cannot act automatically before a French court or before a German court. So you need to have multiple legal teams in different countries that need to be coordinated. Procedures are, again, in the language of the country. So that is quite a complex situation and is very, very costly again. And I think this is probably one of the most annoying things about the current system. It might be that the French judge says, oh, your patent is invalid, while a German judge says, oh, no, your patent is valid. And oh, by the way, company X is infringing. So you might have different judgments that are actually completely contradicting each other throughout the European Union, which is, of course, not what you want in terms of legal certainty as patentee and as potential infringer. So how are we going to solve that? And it's actually going to happen very soon, within a little more than a month. The 1st of June, this new system comes into force. The costs are normally going to be reduced quite substantively by having a European patent with unitary effect. I'll go in a bit more detail about what that actually means. For now, so the 1st of June, we will have 17 countries participating, 17 out of the 27 European Union member states. Now you can say that's really not a lot because it's, a little more than half. It's not that much. But if you look in numbers of population and gross domestic products, that is quite a substantial chunk of the European Union. It's almost 80% of the GDP of EU that is covered by these 17 member states. And I'm pretty much convinced that once the system starts running, that it will increase and other countries will jump on board as well. So that's solution to problem number 1. We will get a unitary patent. Solution to problem number 2, so the different national courts that need to decide on your patent will be solved by establishing a completely new court system, which is called the Unified Patent Court. And I'm just going to jump one little bit back here because it's important to note that these two systems are completely separate. A European patent with unitary effect will actually be issued by the European Patent Office as it is today. So it will be as if you validate, instead of before a national patent office, you will validate with the EPO, the unitary effect. And it will be valid then in 17 countries. The Unified Patent Court is something completely different. It's completely independent from the European Patent Office. It's actually also completely independent from the European Union. It's a system that is kind of floating somewhere in between, as with any political compromise, I would say, of course. So it's a supranational court, which is common to the contracting member states, which basically means that it is more or less considered as a national court under EU rules, but it has jurisdiction in those 17 member states from the start. A bit complex to explain, but it basically has the same rights and limitations and remedies as a national court would have. The UPC will have exclusive competence for most actions regarding infringement and validity of UP patents, and these are the European patents with unitary effect I just discussed, but also for the already existing and the future European patents that are not having this unitary effect, so the normal bundle patents, if you like. And it will also have jurisdiction over SPCs on both of these. So you see, this is where the two systems kind of converge. You have the European patent with unitary effect, and you have the court, the Unified Patent Court, which will have jurisdiction over both European patents and European patents with unitary effect. However, there is also a transitional period, which is kind of, again, a political compromise, if you like, starting for 7 years period, potentially extendable to 14 years in total. Oops. I'll just finish my sentence here, which basically means that in this period, both the national courts and the UPC can still be responsible for judging on European patents without unitary effect. For unitary patents with unitary effect, the UPC will have the sole jurisdiction from the start. So, but to give people the opportunity to not select this unitary effect and also not really be in the UPC, there will be also an option to opt out of the system completely. But I'll go back to that in detail. So you can see it's a system that is meant to simplify things, but they came up with quite a complex solution to simplify things. But hey, it'll have to somehow figure out how it works in the end. So let's go into a little bit more detail. And Felipe, please feel free if you see interesting questions to interrupt me, of course.
Actually, Koen, we have one question here. I'm just afraid that you will answer it, end up answering it during your presentation, but I will translate it to you. The question is from Gabriela de Fante. In the year of validation as unitary patent, 17 countries signed the agreement. Therefore, protection was conferred simultaneously to those in those 17 countries. 1 year later, another country signs the agreement, reaching 18. Thus, the protection of that unitary patent is validated in more than one country, or just on the 17 of the year of validation?
It's a very interesting question, and the answer is no. So the cutoff date is going to be the moment where the unitary effect is requested. So the number of contracting states at that time defines the number of contracting states that will fall under this unitary effect for the rest of the lifetime of the patent. So it's not as if it's cumulative if more countries exceed? It's a very interesting question. And indeed, they could have done it the other way around. But I think legally spoken, it was a bit tempting because it would mean that the same patent would suddenly have jurisdiction in different countries over time, which probably was legally spoken not so easy to implement. So, but the answer is no. The cutoff date is really the time of requesting the unitary effect.
Thank you.
So let's go into a little bit more detail regarding this European patent with unitary effect. We call it unitary patent, but the official name is European patent with unitary effect. So as said, we had this situation previously, or we have it today, where after grant, you have to decide which countries you want to have the European patent validated. And that is going to change into a system where for these 17 member states we discussed, you will have the possibility, again, it's a possibility, it's not obligatory, to choose this unitary effect. And you will get a unitary patent that is valid in those 17 member states. What does that mean? It means that it will have unitary effect in those member states. It will imply paying a single renewal fee to the European Patent Office instead of having to pay 17 renewal fees to 17 different countries. You will have to provide a single translation of the patent. To give you an example, this is again a compromise. If the patent is in English, then you will have to provide one translation in a language of a European Union member state. More, I mean, to bring it more to your level, let's say, if you would have, for instance, a Portuguese language priority document, that translation could be used, for instance, or as a translation or as a start for a translation for this case. Same if you have different other countries like in Spain or whatever, or in more Latin American countries where Spanish language is needed anyway, you could use this language for this procedure. And there's one very important remark here. The litigation is going to take place before the Unified Patent Court exclusively. So there is no way to opt out. There is no way to choose national courts, which means that you are kind of stuck in this new system, which can be good, which can be bad. We will go into detail regarding that. Of course, since we're talking only about 17 member states, that means that we have well, kind of, we have 39 in total, so still 22 other countries that could still be on your list of importance. And that means that you will still have to do validation in those, one of them being quite a big market, namely the United Kingdom. So you will always have the opportunity to add countries to that. And for those, the normal rules will apply, which means that you will have to validate in these countries separately. So you will get like one bundle of 17 countries in one time, and then you will have to do the validation for other interesting countries separately. So that, of course, applies for all the non-EU countries, but also for the non-participating EU countries for the moment, like, for instance, Poland, even Romania, and some other countries. Okay, so that's how it will more or less exist in the future. We will still have the national patents, which can still be interesting if your market is only in one specific country. You will still have the classical European patents, which you can validate in a number of countries. And then we will have the European patent with unitary effect. And most likely you will have somewhere a mixture between the two. You will have potentially the unitary effect plus classical validation in one or more other states, like, for instance, the UK or Norway or Poland or whatever. So this is what is going to be possible in June. And again, keep in mind that it's an option. It's not obligatory. There is always the option to stay with the classical EPs.
So, Koen, we have another question here regarding translation. If my application is in English, do I need, it's from Eduardo Quadros. If my application is in English, do I need to submit a translation in another language, even if English is already accepted for the EP? And
So
there's a follow-up question. Do I have a certain period of time, limit of time, to decide which of the 17 countries do I wish for protection?
Okay, so I'll first start with the language question. So there are two main possibilities. So you know that the European Patent Office grants patents in 3 languages. English is the majority, then French, and then German. If the patent is granted in French or German, then you will have to provide a translation in English. That's the simplest situation, let's say. If the patent is granted in English, then you will have to provide a translation in whatever language of the European Union. So, for instance, French or German or Spanish or Dutch, if you like, no matter which, or Portuguese, that's all possible. And that needs to be done within 1 month's time after the publication of the grant. That's for question 1. For question 2, regarding the 17 member states, there is no possibility to choose. So these 17 member states exist at the time of grant. It might be in the future that it becomes 18 or 19 or 20 or hopefully 27 contracting states, but it will always be this cutoff date of publication of grants, which decides which countries will be in the package. So there is no choice to make there. It's not possible to choose unless you go for the classical European patent, but then you don't ask for unitary effect and you just choose the different countries, and that needs to be done within 3 months from that date of grant. Okay.
Thank you, Koen.
So going into a little bit more detail on this unitary effect and uniform protection, we used to have the situation, or we have it still today, where it is possible to have different claims in different member states. That can be, for instance, because there is a national prior right document that is only applicable for validity in said specific country. And then you could limit, for instance, the claims for Portugal or for Spain or for Belgium, if you like, and keep the claims broader in all the other countries. That is not the case with the European patent with unitary effect, because we need to have the same set of claims in all participating member states. It's again a bit of a compromise. You get uniform protection, but it also means that you need to have the same claims everywhere. This unitary effect also has some other consequences. It means that you cannot sell, for instance, or even limit or revoke or have it lapsed in one of the member states only. It needs to be limited, transferred, or revoked or lapsed in all of these member states at the same time. That is a bit of a drawback, because some of you who are aware of or have been using the European system, what often happens is you start out maybe with 5 or 6 countries for the validation after grant. And then after a couple of years, well, the market is not so important anymore, and you limit to only, for instance, the biggest markets like UK, France, and Germany. And the rest of the countries you basically abandon. That's not going to be possible with this unitary effect, since we need to have this uniform protection in all 17 member states. So although, and we'll come back to that, the fees are strongly reduced, you will always be stuck with this group of 17 member states. There is no way to carve out some member states from that protection. What is still possible, however, is to license only part of the territories. So instead of selling and transferring, which needs to be done over the whole territory, licenses can still be written out for part of the territories. Okay. So how is the situation today? So we have 12 states that participated in this procedure. Well, there's two. Well, I'll go to the second one. This is probably the most interesting figure. So although we have 17 states that ratified the UPC agreement, there are actually a couple more states that have given their intention that they will ratify in the future. So we will probably go up to 25 pretty soon. There are some countries who have said, no, we will not participate, never ever. One of them being Spain, because they are not happy with the language regime. Another country in dark red here is Croatia, for the simple reason that they were not part of the European Union yet at the time this agreement was established. So I think for them, there will be a possibility later on. And also Poland, for instance, has indicated that although they did sign the initial agreement, they will not ratify it because they are kind of scared that it might hamper their economy. Okay, something to be seen. Every new system, of course, comes with a lot of question marks and uncertainties, and that is why some countries are a bit hesitant to participate from the start. But anyway, I said already, 17 states, including Germany and France and the Netherlands, Sweden, Finland, and whatever. Italy is also a big market. Portugal, of course, as well. Is quite a big chunk of the European Union, and hopefully it will grow over time. Okay, this I will skip because I have more or less said it already. Yeah, and this is maybe the answer to the question previously. So you will have successive generations of unitary patents for years. So you will have the initial ones that were granted, let's say this year, that are valid in 17 countries. And then maybe next year you might have 18, and the other years after it might go up to 25 countries in the end. So it will make things a little bit more complex in terms of, for instance, freedom to operate for us or for foreign clients, because you will have to always look back when was it granted, how many states were in this system, and so on. So it might complicate things a little bit for these analysis as well.
And I have another question here from Otoko. So is it possible to get into the UP, I think it's UPC, the Unitary Patent, without getting into the EP first or simultaneously? Means to jump UP and get into EUP, 17 countries, and the remaining countries would get by EP. I think that the idea would be to have the unitary patent without having the European patent, and then for the other countries outside of the 17 countries to have
The
an
European
EP.
patents. Yeah.
Yeah.
No, so you have to go through the normal granting procedure at the European Patent Office in order to get this unitary effect. So although the two systems, of course, will coexist, you will have the same European patent upon grant, which can be both having a unitary effect in those 17 member states and then being validated in the UK, in Norway, in Turkey, and so on. But you will always have to first go through this search and examination stage at the European Patent Office before you can start. So there is no way to skip this.
Thank you.
So what about timing? Well, I think most of you have read that everywhere for the moment. We are lucky. Germany ratified the agreement, or actually deposited the ratification somewhere in February, which triggered an entry into force date, which is going to be the 1st of June of this year, which is approaching very fast, of course. So when can you request this unitary effect? Well, only for European patents granted on or after this date. That has some implications, of course. I'll come back to that in a bit, but it basically means that if a patent would be granted today, you would not yet be able to request this unitary effect, which would be silly, of course, if you're interested in. First of all, it has to be done before the European Patent Office. And secondly, the timing is very short. It needs to be done within 1 month after grant, as I already mentioned. So again, you have to be sure that the claims are the same in all the participating member states, which is normally the case. But for instance, one issue for old patents, if you would have like a patent application that was filed in 2007 or prior to 2007 and is still pending, or you have a divisional of an application that is that old, you might have an issue because Malta, which is now a member state of the UPCA, was not yet a member of the EPC. So it is not designated in those applications. So for those older patents and patent applications, there would be a problem because you would not have the same claims for all participating member states, and you would not be able to get that unitary effect. But okay, that is pretty rare, of course, since that's about 15 years ago. So there's very little patent applications that have not been granted by then, but there are some available, of course. This unitary effect is free of charge, so you don't have to pay a fee to the European Patent Office. And again, as I said, you have to provide this single translation. Again, this is only for a transitional period of 6 to maximum 12 years. Why do we have this transitional period? Because there were some countries that were concerned that they would not have access to a translation in their own language, because machine translations were not powerful enough. You have to realize this agreement was made in 2012. So more than 10 years ago. It only enters into force now, which is kind of amazing, but hey. But the machine translations have meanwhile increased or improved enormously. So it's very unlikely that we will go beyond this period of 6 years for this transitional period. And then, as said already as well, there needs to be paid one renewal fee to the EPO. So this is what I was talking about, these transitional measures. They started this January of this year, which basically means that you can delay the issuance of a decision to grant, and you can file an early request for unitary effect. Both of them are important. Again, as I said, if a patent would be granted today, it means that you cannot yet request this unitary effect. So that implies that you can delay responding to this so-called intention to grant by stating, look, I want to have unitary effect, but please delay the grant until the 1st of June, such that I can request the unitary effect. And what will happen is that the patent will then be granted upon the entry into force of the UPCA. So you kind of shift the deadlines a bit. You can already request early unitary effect, but again, the effect will only be registered at the time the system enters into force in June. Yep, this is what I wanted to say. I think this is about the translation. I have more or less already discussed this. So if the patent language is in English, you need to provide a translation into any EU language. If it's in French or German, you need to have a translation in English. The EPO is not going to check the translation, so you could, in principle, provide a machine translation. However, it's explicitly forbidden to do so. But since they're not going to check, I will not worry too much about it. Okay, let's go to the cost. So I talked about this renewal fee. That's going to be a single renewal fee. And this is how it looks like You can see that from year 2 onwards, it's of course very cheap, 35 euros. In the end, at the, let's say, 18, 19, 20 years, it's almost 5,000 euros, which is quite expensive. Where do these rates come from? Well, basically what they did is they combined the rates of, at the time, UK, France, Germany, and the Netherlands, 4 countries, and they made some kind of an average of those fees, these cumulative fees. Of course, the UK fell off, but they decided not to reduce this renewal fee because that would reopen the whole discussion, and they actually feared that nothing would happen in the end. So they just kept the fees as they were. What does that mean? Remember one of my first slides, I have this hilarious figure of 180,000 euros in 20 years. Now for those 17 member states, that would only be 35,000, which is still enough, I know, but it's at least a serious reduction in costs. Of course, the drawback is that it only applies for the moment for 17 EU member states. Still, it's quite a substantial reduction. Now, of course, everything is relative. If you're used to having a European patent validated in 3 countries only, like the UK, France, and Germany, the biggest markets, well, then the system is probably not so interesting for you because in the end, it's going to be more costly than what you usually do. If you look at this graph, these are the cumulative costs for choosing 1 country, 2 countries, 3 countries, 4 countries, and the dotted one is the UP line. So you see when you start to have 4 countries, maybe 5, then it becomes interesting to choose UP. If you have 4 countries and you choose unitary effect, it basically means that you get you get protection for 17 countries instead of 4 countries, right? That's how you have to more or less interpret this system. Always keeping in mind that the UK is not part of this system, unfortunately, due to Brexit, which was, of course, a big chunk of the market as well. But yeah, life is life. We cannot change that. It's going to take a while before the UK enters the European Union again, although I am convinced that they will at a certain point. But I didn't say that. Okay, so yeah, one of these things that are sometimes a bit forgotten is that this unitary effect has to stay for the whole lifetime of the patent, meaning you cannot carve out countries that you're not interested in anymore. Which is what you can do, for instance, if you have the classical validation. You can start out with 5 countries and then delete or abandon 2 countries in the end and so on to reduce the costs, always evaluating whether there's a good balance between the interest in the patent and the costs involved. With the unified system, you don't have that possibility anymore. It's either those 17 countries or none of them. It's an all or nothing situation. So also something to take into consideration if you want to make a calculation regarding cost benefits. Yeah, this I have discussed. This is just an example of how you can more or less determine whether it's interesting for you or not to go for a unitary patent or not. If you only are interested in Germany, for instance, then in the end, it's going to be more expensive if you ask for unitary effect, although of course you get 17 countries instead of only 1. But if your market is only in Germany and you're not interested in the rest, then it's not valuable. The same holds true for Germany and France and a 3rd country. Once you start having 4 countries or even more, and you start to have also translations involved, it becomes interesting to use this unitary patent approach. Okay, so as already said, and as already one of the questions was posed on that sense as well, patent prosecution stays the same. There is nothing changing. There is no changes in the substantive law, in the way it gets granted. It's exactly the same as for all European patents as we have today. But after grant, you have this 1 month period with an option to validate, let's say, if you like, as a single unitary patent in those 17 countries with a single maintenance fee, one translation only, and only for those member states that at that time have ratified the UPCA. So again, the grant date here is important. It will always remain optional. There is no transitional period for that of 6 years or 7 years or whatever. There will always be the possibility to have the normal, if you like, European patent or the European patent with unitary effect. It's a one patent in all participating member states system, which means that if you let it lapse due to non-payment of the renewal fee, if you revoke it or you limit it, it will always apply in all those states at the same time. But again, licenses are possible for a limited territory. And that is where we're coming to now, enforcement will always have to be done through the Unified Patent Court. There is no choice there. So what is that Unified Patent Court? This is probably...
I'm sorry, I still have one pending question regarding the Unitary Patent. Before we move on to the Unified Patent Court. It's from Barbara Bonatina Padilha. Her question is, what if one of the countries leaves the UPCA? And my patent that was granted with the unitary effect, will it lose the effect on that country that has left the agreement? How will that play out?
What a nightmare scenario.
Yeah.
I don't know the answer to that. But it's definitely something that I could look into, because it could be the same. It could be either leaving the UPCA or leaving the European Union as a whole, which is also not impossible, of course, as we have seen with the UK. I don't know. I have to go back to you. I assume that the rights would still remain because the cutoff date is the date of grant. That's how the law is written. So it's the member states that have ratified the UPCA agreement at the date of grant. If that changes afterwards, I would assume that at the date of grant, they were still in. So it would still be in that system. But that's something that I can look up in more detail and come back to you.
Okay, thank you.
Let's hope that never happens.
Yeah.
You had another question still, Philippe? No? Okay.
No, we can go on.
So the Unified Patent Court. So as said, it's kind of an exceptional court. It's not a European Union court. It's really you can compare it with a bundle of patents. It's actually a bundle of national courts. They will also have a mixed setting of judges from different national courts. It's established by this famous Unified Patent Court agreement. So it's a court common to all the UPCA contracting member states, and contracting member states means the ones that have ratified the agreement. It has the same legal obligations under EU law as any national court. So it's really like, as we call it, a supranational court. It's not really an international court. It's really a combination of national courts, which is set at the same level as any other national court within the European Union. That's important because the initial idea was to really establish a European court, which would then be subject to rulings from the Court of Justice of the European Union. And there was a lot of protest against that, especially by the UK at the time, because the Court of Justice of the European Union, who has ruled already many times on, for instance, SPC regulations, which are EU law. And they always make things more complex than it should be. So instead of answering questions, they create 5 more questions. And that is why the Court of Justice really was not involved, and they made it into a supranational court instead of an EU court. So the Unified Patent Court Agreement will apply to all patents with unitary effect, European patents with unitary effect, but also, and that is interesting to know, to the normal European patents that have not yet lapsed at the date of entry into force of that agreement, and those that will be granted subsequently. It also applies to pending applications or subsequently filed applications, and to supplementary protection certificates. For those who don't know what that is, these are patent term extensions, if you like, for medicinal or crop protection products. So that's interesting to know, right? We have the European patents with unitary effect, but also the normal European patents. And we'll come back to that in more detail. So it's a single court, which is going to be competent for most questions of patent infringement and validity. It will have, of course, a single set of substantive provisions on the rights, limitations, and remedies, one set of procedural law, and of course, at the end, a single decision, which is going to be enforceable directly in all UPC contracting member states. And between brackets, possibly even in non-participating EU states, but that is still to be seen because it's a supranational court, the normal rules in the European Union would apply as they would apply for a decision of a national court, which means that there might, in some cases, be recognition by the non-participating EU states of a decision of the UPC. But that is still kind of blurry, and we'll have to see how the national courts will decide on that. So basically, you ask the court one question: is my patent valid, or is my competitor's patent valid, or does my competitor infringe? You will get a single answer, yes or no, and you may like it or you may not like it. But there is very little you can do except for going into appeal against that decision. So unlike what we have today, where in these 17 countries, you could potentially have 17 different outcomes, in this case, you will only have one outcome. That is, of course, interesting if it's in your favor. It's less interesting if it's not in your favor. As already hinted at, these normal European patents for which you do not request unitary effect will also be subject to rulings by the Unified Patent Court, but you can opt out from this system. And that's the famous transitional period of, and this time it's not 6 years as for the translations, it's 7 years and potentially 14 years, where there is, there's actually two things that are important. There will be a choice between the national courts or the Unified Patent Courts. That's going to exist in any case for in the 7 years. And in the 7 years, you also have the option to opt out from the UPC, from the competence of the UPC. So in any case, if you don't do anything, your patent is granted today, the Unified Patent Court enters into force after the 1st of June. If there is a litigation that you want to start, you will have to choose either between the Unified Patent Court or the National Court in Germany, France, Belgium, wherever. But that doesn't only count for you as patent owner or as patent holder, it also counts for the potential infringer, your competitor in Europe, who might force you into one of those routes. They might force you into a national court, or they might force you into the Unified Patent Court. Because if they are the first to start an action before either one, then the court is seized and you're stuck in that situation. If you want to keep control as patent holder, then there is a possibility to opt out of this UPC agreement, which means that a competitor cannot attack you before the Unified Patent Court, but could only go national, which might or might not, depending on your market and depending on the territory of activity of that competitor, be an interesting or a less interesting situation. Of course, every case is different. What is also interesting is that you can also withdraw this opt-out later on. So if you want to avoid being in the UPC agreement because you're not 100% sure what it's going to give, and you prefer not to put all the eggs in one basket, let's say, and keep the national courts responsible, then you should go for an opt-out. And if in a couple of years you see, oh, my competitor is actually infringing in 5 countries at the same time, I don't want to file 5 infringement cases in 5 different courts. I want to go back to the Unified Patent Court. Then you can withdraw this opt-out, provided that your competitor has not yet started an invalidity proceeding or a declaration of non-infringement before a national court. So that's kind of the situation. So it's lawyer's paradise. There will be a lot of strategic discussions, I will say, between both patentees and alleged infringers. But that's what we have in this transitional period of 7 years. Whether or not it will be extended to another 7 years will very much depend, of course, on the success of this system and how consistent the rulings of the Unified Patent Court are. Remember that if you have European patent with unitary effect, there is no possibility to opt out, and there is only one court that is competent, which is the UPC. Okay, so those two are really separate systems. So if we have to make like a chart of the competences of the court, for a national patent, the situation is quite clear, of course. There is no unitary effect, and the competence only lies with the national courts. For a European patent without unitary effect that has not been opted out, so there is no unitary effect, you have the choice. Either the UPC can be responsible or the national courts can be responsible. Of course, if a procedure is started in either one of them, it kind of excludes the other one from competence. If you have the European patent, the classical European patent opted out of the UPC system, again, you have no unitary effect, but only the national courts will be competent here. Or, as my little asterisk says here below, again, the Unified Patent Court when you withdraw the opt-out after time. And again, for the unitary patent, there is only one option. You have unitary effects, and the Unified Patent Court is the only competent court. Okay. So when does this enter into force? Well, at the same time, of course, as this unitary patent, which is June 2023. We have a sunrise period which started the 1st of March. Why is that? Because if you want to opt out of this UPCA agreement, in principle, you can only do that the 1st of June. But if somebody already files a lawsuit before the UPCA also on the 1st of June, then you get into this catch-22 situation where the court basically cannot decide who was first and whether it was actually opted out before you filed the complaint or after, and so on. So that's why we have this sunrise period. We're right in the middle of it now, where we are very happily opting out a lot of patents for many of our clients. Not for all of them, I must say. It's really a strategic decision to make, but it's definitely something to consider. So all the opt-out applications during the sunrise period will be deemed to have been filed at the 1st of June, and there will not be a possibility to file a lawsuit before the Unified Patent Court. There are some peculiarities with opting out. Because we have this unitary aspect there, it's important that all the applicants and proprietors, and the important word here is the actual applicants and proprietors, must cooperate for the opt-out and must agree to the opt-out. To give you an example, if you have sold the patent to another company, but you didn't register that in the at the European Patent Office because, well, not everybody needs to register it if you don't really use it. If you want to opt out, or if the party who bought your patent wants to opt out, they will have to file a declaration that they are the rightful owner. Because if you would look in the European Patent Register, they will still see your company as the rightful applicant or owner. So there's a bit of a work involved, let's say, in order to get everything formally organized. But it's important to know that, especially if you have multiple applicants or proprietors, they all must agree and all must sign the necessary documents in order for the opt-out to be valid. It also needs to be lodged for all the states in which the EP has been granted. So not only for those 17 member states, but for all the EPC states for which it has been granted. It also automatically extends to SPCs if that will be of interest. So if European patent has been granted, you opted out, and later on, at the end of the period of the patent, you request for supplementary protection certificates. These will automatically be deemed opted out as well. As already said, you can also withdraw the opt-out once. So it's not a yo-yo effect, which you can continue throughout the life of the patent. You get one shot, let's say. You can opt out and withdraw the opt-out. But then you would again be in this unified patent court system. What else is interesting for you to know? Yeah, that's not so really important. It's already what I said. So sunrise opt-outs will be deemed to have been opted out on the 1st of June. That is why we have been really advising our clients not to wait too long, because the system is not always that stable. And if we have to do it last minute, there's always a chance that it's not registered in time. So be aware of that. The 1st of June is not that far away anymore. If you would like to do opt-outs, don't wait too long to contact your agent. So where does this unified patent court apply? Well, again, in exactly the same states as for this European patent with the unitary effect, because these two are linked. And so the unitary effect only takes place in the countries that have ratified the UPC agreement. Why? Because the UPC is the only court responsible or competent for European patents with unitary effect. So there needs to be a link in that end. How is it structured, this new court? So we have local divisions, central divisions, and regional divisions. I'll come back to that in a bit. The regional division, there's only one for the moment, is the Nordic-Baltic division, which encompasses Sweden, Estonia, Latvia, and Lithuania. And all the others are local divisions. Like, for instance, we have one in Belgium that actually uses 4 different languages. There's 4 in Germany, for instance. It is kind of dependent on the number of law case or court cases you had, patent court cases you had in the previous years. And then we have a central division in Paris and Munich. There used to be also one in London, but due to Brexit, of course, that was a bit difficult. So that might or will probably or very likely be Milan. Why do we have different central divisions? Because they are actually classified in terms of technical field. So this is what the situation looks like in the first instance courts. So we have local divisions, central divisions, and regional divisions. And then a second instance court is installed up on top of that, which is the Court of Appeal in Luxembourg. And my good friend in Belgium would kill me if I do not mention this part. There's also an arbitration and mediation center, which is completely new, and it's part of the court structure, which is going to be in Lisbon and Ljubljana, because they also have a new system, let's say, for amicably regulating disputes rather than going to court all the way. Now, the Court of Appeal can also refer questions to the CJEU. And you see it's put kind of in brackets here or in dashed lines. There is no direct link with the CJEU just because nobody wanted the CJEU to rule on standard patent cases because they are not patent experts. But of course, there is a possibility for the Court of Appeal to refer questions to the CJEU if it comes down to legal issues, like which law applies, which language regime applies, and so on. How do these, or how are these divisions populated? So we have the LQJs are the legally qualified judges, and the TQJs are the technically qualified judges. And you see that in the central division, there's a mixture of both. And in the local divisions, in principle, not unless there is a revocation counterclaim. Why is that? Because normally the central division will mostly deal with revocation actions, while the local divisions will mostly deal with infringement actions. So they kind of separated those two. Legally qualified judges are national court judges that have experience in patents. They have been selected for, I don't know, about a year. They have undergone training. They are still undergoing training. Technically qualified judges are basically people like me, patent attorneys, who are court experts, for instance, that do a part-time job advising the legally qualified judges on technical issues. Like you can imagine if you have a pharma case, a legally qualified judge might not understand the chemistry behind the pharma, or equally valid, a very complex gearbox, if you like. You cannot expect a legally qualified judge to understand how that all works, and that's why they can involve a technically qualified judge. How are we on time, actually, Felipe? Am I exceeding my time a bit? Yes, probably. So I maybe.
Hi, Koen. Yeah, we exceeded a little bit, but we still have a good number of participants and a couple of questions. I think we're good. If you want
I think we have
to
like maybe 10
jump
minutes or something. Yeah.
To highlights,
yeah.
Go ahead.
So the only thing I wanted to mention is that is this part here. Infringement is going to mostly before the local and regional divisions, revocation before the central divisions. But they might also sometimes consolidate cases if there is a counterclaim, for instance. So it's kind of a complex system. If you look at this, for instance, quite a number of local divisions to choose from. Some of them have different languages that you could also choose from. So it will involve a bit of forum shopping depending on the judges, depending on the languages used, and so on. So strategic considerations, which is a bit wrapping up, let's say, the pros and cons of the two systems.
So I still have, I'm sorry, I still have two questions related to the UPC specifically. So one is from Renata Anduzieni. She wants a clarification on the question of enforceability of an UPC decision, even in countries that have not joined the system, like UK, Poland, Spain, etc. She would like, I think she would like to know how that will play out in practice. And the other questions from Motoko regarding the subject of litigation: is there UPC courts that will deal with infringement according to different matters? For example, mechanical matters will be dealt by some UPC courts, and another for chemical matters, or each court will have their own expert judges?
I'll maybe start with that one because I already more or less explained it. So if it comes down to questions of validity, then there will be this separation of technical areas. So normally spoken, London would have had all the competence for pharma and biotech, for instance, life sciences. Now that is distributed between Paris and Munich. But yes, so they have different, let's say, expertise fields based on the classification code of the claims of the patent. So based on that, you will either go to one court or the other. What the situation is exactly going to be, we still don't know, because the decision has not been made regarding Milano and what they will exactly do. In terms of infringement, that's not really the case, and that's why we have these technically qualified judges that come in to compensate for the lack of technical knowledge, if you like, for certain fields. The other question regarding enforceability of a decision of the Court of Justice into non-participating member states. Well, there's two levels there. If they're part of the European Union, then they are, of course, bound to European Union law. And European Union law has provisions that provide for enforceability of decisions of national courts into other member states, unless they are completely contradicting the, let's say, regular situation in said country. So this recognition, as it is called in the law, applies between national courts already within the European Union system. And it is assumed that since this Unified Patent Court is a supranational but treated as a national court, these decisions will also be extrapolated to the non-participating EU member states. Whether it will go beyond those states depends really on international agreements. Like there are agreements with Switzerland, for instance. It's called the Lugano Agreement, if I'm not mistaken, where they have similar mechanisms that decision of a national court in the EU is also applicable in that contracting state if, for instance, the infringement or an injunction would have to be taken into account. Beyond that, that is really very much dependent on international treaties, like the UK, for instance. I'm pretty sure they will not accept any jurisdiction of the UPC anytime soon. But yeah, that's more or less how the system works. So within the European Union, there is really a clear framework. Some satellite countries have agreed to the Lugano Agreement and basically extrapolated the same rules into their own law. But further than that, it seems doubtful that the UPCA would have, or the decision would have an effect in those countries, at least not automatically. Maybe that will change in the future, but that's not 100% clear for the moment.
Okay, thanks, Koen.
So, strategic considerations, if we're talking about this unitary effect, of course, it all starts with what is my desired territorial scope. Am I interested in only the UK? Well, there is no use in having unitary effect because the UK is not even in there. Am I interested in 6-7 countries within this group of 17? Yes, then it's probably a good idea to go for unitary effect if you want to reduce the costs. Again, keep into account that you cannot downsize the UP countries once you have this unitary effect. So it's a 17 or nothing system. The competent court is, of course, also a consideration to make if you want to keep all your eggs in one basket or you want to spread the risk. That can, of course, rely also on the strength of your patent versus the risk of revocation. If you think your patent is very strong, then, well, there is no reason to not go for the Unified Patent Court because you're convinced that your patent will uphold, for instance. These are the most important things, I would say. Let's go to the pros and cons of the Unified Patent Court, maybe to almost finalize my presentation. So, of course, its advantage is to only have a single court proceedings. However, are there also disadvantages? Yes, more or less, because we do not really know what the type of decisions are going to be. Are they going to be patentee friendly? Are they going to be more defendant friendly? That's very difficult to know, and it will probably also differ from division to division, because, for instance, in Germany, you have 4 divisions, which will most likely be comprising at least a majority of German judges. So you will have a very German-focused litigation in those divisions. In Belgium, because we're a small country, for instance, we will only have 1 Belgian judge, which will be complemented by 2 other nationalities. So there you might have a very mixed approach. So it's kind of difficult to know for the moment what is going to happen. What's also important to note, and I'm not sure if I really have a slide on this, but the UPCA intends to have decisions made within 1 year from the start of the procedure, which is very, very fast. That's an advantage, of course, if you want to have a quick decision. It's also a disadvantage if you're not prepared, because you have very short deadlines to reply. To give you an example, most deadlines are 1, maximum 2 months in order to provide a full response to, for instance, an invalidation or an infringement action. So it's very short, which means that you need to, if you expect litigation, you need to really be prepared, because it's going to involve a group of lawyers in order to prepare the case. It's a very much front-loaded system as well, so you will need to provide all evidence from the start, and everything you add later might or might not be entered in the procedure. So it's going to be a tough one, let's say, but again, a paradise for lawyers, I would say. Oops. Let's see what we have here. Yeah, an advantage is that instead of, for instance, in a lot of countries that are not so experienced in patent law, where you have a judge that one day has to rule on a divorce and the other day has to rule on the bankruptcy of company X, and then today suddenly he has to rule on the infringement of a pharmaceutical case, you can imagine that it's not that consistent in terms of decisions. That will of course change. You will have specialized patent judges, including technically qualified judges, so the quality can only go up, I would say, in my view at least. The costs will also, in the end, probably be lower than if you have to go to 5, 6, 7 countries at the same time, because you only have 1 procedure. There's only 1 drawback: the loser pays, which means that you can, if you lose, for instance, a case in infringement or in invalidity proceedings, you can or you will be forced to pay also not only the court costs, but also the costs of the other party. So the costs involving the lawyers and representation, which can be quite high. So that is potentially a risk if you have a granted European patent. You foresee litigation or you see a risk in litigation, then you might have an advantage in opting out, because then you at least avoid this potential risk of ending before the Unified Patent Court and having to pay a lot of damages. Well, not damages, but court fees, if it all goes wrong, let's say. Just checking what I have here still. That I have already. Yeah, these are like examples, let's say. So in general, and of course, if we have to make it black and white, so there is not a single case that is black and white, but if you're certain of the validity of a patent and you envisage pan-European litigation, then there is no risk in staying in the Unified Patent Court, and I would not do an opt-out. If the validity is not so strong, it's questionable, and the scope is maybe limited, it's more like a defensive position you have, then opting out might be a good point, because then you avoid the risk of having to pay the costs of the other party if you would lose in a case. If you're certain of the validity of a patent and you envisage pan-European litigation, then again, if we're talking about unitary effect or not, go for unitary effect because you will really, let's say, save a lot of money. And again, that will link your patent to the Unified Patent Court. If the validity is questionable, but it's more a defensive position and your competitors are not really into litigation or are not very aggressive, then why not go for UP as well? Because the risk of ending up before a court is low anyway, and you will reduce the costs. But if validity is questionable and the market is competitive, your competitors are litigious, then maybe it's safer to go for classical validations and opt out of this system. So, as said, we are now, well, what is it, 26th of April? So the time is running out for opting out if you want. You have to opt out before June 1st if you want to avoid all the risks. So make sure that you have a strategic view on this and have talked to your agent or your IP manager to see what you should do. Make sure if you have licensing agreements in place that you also talk to the either the patentee if you are taking the license, or to your licensees if you are the one offering the license, to make sure that there is no conflict there, to also be aware as to who is in control, who has the right to make those decisions. And something also for the future maybe, and that's how I will end. Make sure you also adapt potentially the licensing agreements for the future to make sure that you have these action points already in there for future agreements, to make sure that there is no discussion. And that's the end of my presentation. Maybe very briefly here, I can refer to our website where we have a dedicated page with all this information, and also a brochure. And if you have questions, you can always contact me or Felipe, of course, and his colleagues. They will also help you out. Thank you very much.
Thank you, Koen, once again. I was kind of smiling when you said that the 1 to 2 months deadline to reply to an invalidation request at the UPC is too short, because we have a 2 months deadline for invalidation lawsuits, to reply to invalidation lawsuits in Brazil, and 15 business days to a deadline to reply to infringement lawsuits. So here in Brazil, things are a bit sped up on the side of deadlines, but that was a very insightful presentation. I have received some very positive comments. For me, as a patent litigator who has already had the experience of trying to coordinate litigation in Europe and Brazil, this is very interesting to surely help, and it's very interesting to keep updated on the developments of the UPC once it is going, once it is working. We have a last question here from Gabriel de Blasi. As for unitary patent, if one country joins UP after June, and the patent granted that opt-in to UP happened before June, will the patent have the rights to claim the validation in this country? Yeah. So what is your take on that? I think that it is the question of
what happens when more countries
it is the
exceed
same issue of when the country joins after the patent has been granted with unitary effects.
Exactly, it's the same issue, and again, it's the date of grant that is important. So then the member states that have ratified the UPCA agreement, or the UPC agreement, sorry, at the date of the grant of the patent will establish which countries will be in this system for this unitary effect for the rest of the trip, let's say, and the rest of the life of that patent. And the same is true for the jurisdiction of the UPC in the end. It will also be the same decision, let's say, made at the time.
Okay, thank you, Koen. We don't have any other questions, and we have crossed over our time limit. But thank you once again. It was very instructive. We had a lot of participants. I'm sure everyone learned a lot today. And thank you once again. I'd like to reinforce that if you have any additional questions, you can contact Koen. If you have any questions regarding your EP applications or patents, you can address them to us as well at Blasi Parente. Thank you very much and have a nice day, everyone.
Thank you for having me. It was very nice to present this for you all. Thank you.